Okay, I think we might get started. So hello everyone and welcome to today's webinar, Making a Will with State Trustees. So my name is May Sivashambu and I am your host and also a relationship manager here at State Trustees. Before we do begin, I would like to acknowledge the traditional custodians of the land on which we gather today, and we extend our respect to Aboriginal and Torres Strait Islander peoples joining us today. So before we begin today's session, I do want to thank you all for joining us. For the first time ever, this session is fully booked out. And it's so great to have so many of you here today, taking this really important step towards ensuring that your financial and legal affairs are in good order. Now, many people do put off making a will. And in fact, did you know that 53% of adults don't have one? And if you're part of that statistic, don't worry, you're definitely not alone. So I was also in the same position when I started at State Trustees. And I thought I was too young and I didn't need a will, and I never got around to it. And it wasn't until I started working with many clients from all walks of life that I truly understood that if I died without a will, how much of a burden it would be for my loved ones. Now, today, we're going to take you through the will writing journey. So our goal is to get you comfortable with the process of creating a will that suits your needs. So by the end of the webinar, we want you to feel empowered and confident about knowing exactly why creating a will is so important and how to go about creating your will with the help of our professionals. So what will we be covering today? We'll take you through why creating a will is so important and what happens if you don't have one, and what to expect when you meet with a will writer at State Trustees, and how we ensure that your will is legally valid and accurately reflects your wishes. And of course, we'll be answering some of your questions as well. So throughout the webinar, please feel free to type into the chat feature any questions that you might have. And in our Q&A section, we will try and cover them as much as we can. Now let's talk about who we are. So State Trustees is a Victorian government-backed company who provide financial and legal services to Victorians during important life moments. So we write more wills than any other organisation in Victoria, and we truly understand the complexities of the law relating to wills and estates. So with over 120 years of experience and more than 350,000 wills prepared, we've seen it all. And our diligence, care and expertise are here to support you, giving you peace of mind for the road ahead. And for us, peace of mind means helping you know what will happen when your assets are, what happens to your assets after you pass, and making sure that your family is well taken care of. Now, I'm really excited to introduce you to someone who truly makes a difference at State Trustees, Grace Mauro. So Grace is a qualified lawyer with over 10 years of experience across practice areas, including wills and estates. She also leads a fantastic team of will writers here at State Trustees. So Grace and her team have a unique blend of professional expertise and genuine care. They've all practiced at various law firms in Victoria before bringing their wealth of knowledge to our wills team. What makes Grace special is her ability to make complex legal matters so easy to understand and ensure that every client feels confident and at ease. And also her team is set up to provide that level of service when you meet with them too. So Grace and her team will be able to help you prepare a will that reflects your unique wishes and circumstances. But it doesn't just stop there. They can also assist with helping set up powers of attorney, so that ensures that a trusted person can make decisions on your behalf if needed. And they'll guide you through nominating an executor, whether that's a person you trust or a professional organisation like State Trustees. Now, I think you've probably heard enough of my voice for now, so I'll pass it over to you, Grace. Thank you so much for joining us.
Thanks, May, and thank you all for taking the time to join us today for this special webinar. We'll get started. So for some of you here today, it may be the first time you're considering preparing a will. For others, you may already have a will but are thinking about whether it's time to update it. Wherever you're at with your journey, it's helpful to understand what to expect so that you can feel comfortable in taking the next steps with State Trustees. So firstly, what is a will? A will is a legal document that outlines your instructions about who you want to inherit your estate, care for your children, and be your executor. When you die, your assets are referred to as your estate. Your estate can include things such as real estate, so property such as your family home, your car, bank accounts, other personal items such as special pieces of jewellery, and even your beloved pet. There are other complex circumstances that we can help you with as well, such as how to deal with your small business after you die, what to do if you're a beneficiary of a trust, or if you'd like to establish one in your will, or if you'd like to donate to a charitable cause. So a will must be a written physical document, signed and witnessed in a very specific way. No videos or voice recordings are acceptable. A will appointment is a service that caters for all clients, whether your wishes are simple or complex. A professional will writer will meet with you in person to guide you through the decisions that need to be made and answer your queries as you go along. So next I'll talk you through a step-by-step guide to writing a will with us and what to expect. Meeting with any professional can be daunting. However, our team of will writers is here to make the process easy for you. With our care and expertise, we'll guide you through each step of creating your will to give you peace of mind that your financial and legal affairs are in order. As May mentioned, our will writers write wills for people of all walks of life. We can draft a will that gives effect to your unique wishes and circumstances. As May mentioned, we've seen it all. Before your appointment, you'll be asked to complete a pre-appointment questionnaire. We'll send this out to you via email, or we can post it out to you if requested. It's important for us to get to know you and your unique circumstances before we meet, so that your appointment runs as smoothly as possible and your will is ultimately as unique as you are. I like to think of it as going to the supermarket without a shopping list. You might remember some of the things you need, but you're likely to forget some important items. That might mean another trip to the supermarket, wasting your time and effort. Similarly, when our clients don't complete their pre-appointment questionnaire before their will appointment, important details could be missed, making it harder for us to create a will that truly fits your needs. It might also mean that you require an additional appointment, which could ultimately delay the will-making process. The pre-appointment questionnaire asks you to provide some important information, such as your personal details, relationship status, and history. Details of your spouse and any children, including who you might like to look after them after you pass away. Details about the assets that you own, including property, bank accounts, investments, vehicles, super, and other personal items. Any liabilities, such as debts, like your mortgage or other loans that you may have. Insurance policies, and any other details that you think we might need to prepare your will. In some instances, you may not have all of the details that we ask you for, such as the value of your home or super. You might find it tricky to get that information in time for your appointment. That's completely fine. Those things won't prevent us from preparing a customised will for you. Simply complete the questionnaire as best you can. Don't worry if you can't fill it all in. We can discuss any gaps when we meet with you. So next we'll talk about what to bring to your appointment. We'll ask you to bring two things: a photo ID, such as your current driver's license or passport, so that we can verify who you are. And the other thing we'll ask you to bring is your completed pre-appointment questionnaire if you weren't able to give it to us in advance of your appointment. During your appointment, we'll get to know you by discussing your pre-appointment questionnaire and answering any questions you may have had before we get started. Then we'll step through each section of your will. We'll discuss appointing an executor. So an executor is a trusted person or company, such as State Trustees, who will manage your estate according to the wishes outlined in your will. We'll also talk about specific gifts to your loved ones, such as a cash gift to your children or grandchildren, or leaving a specific piece of jewellery to somebody special to you. Nominating a preferred guardian to take care of minor children. So when we say minor, we mean children who are below the age of 18. Nominating a willing caregiver for your pets, if you have them. Donating to a charity or cause, which you can do either directly or via state trustees. Provision for any trusts to be established upon your death. This may be a new concept to you or something that you would like to discuss further in your will appointment, which we can absolutely do. And finally, how to distribute your residual estate. So everything left after we've given those specific gifts to your loved ones. We do offer other services as well, as May mentioned earlier. So in addition to preparing your will, we can also prepare an enduring power of attorney or medical treatment decision maker, formerly called a medical power of attorney. So these documents allow you to appoint a trusted person or company, such as State Trustees, to manage your financial and legal affairs if you're unable to do those things yourself. You can also appoint a trusted person to make personal and medical decisions on your behalf. I like to think of a power of attorney as a bit like giving a trusted friend a spare key to your house. If something happens and you can't get home, they can easily step in and take care of things and ensure that everything runs smoothly in your absence. Without a power of attorney, there might not be anybody authorised to handle your important matters when you need help the most. So we've talked about what happens before your appointment. We've talked about what happens during your appointment. Now I'd like to touch on the will finalisation step. Once we've prepared your will, we'll read over it to you and with you to make sure that you're comfortable with it. Once we confirm that your will reflects your wishes, you'll sign the will in the presence of 2 witnesses, which we will arrange, and the result is a legally valid will. We can safely store your original will in the Victorian Wills and Powers of Attorney Bank, and we can give you a copy to take home. After you make your will, you should get in touch with us if your circumstances change. We can always meet with you again to prepare a new will that suits your updated circumstances, such as having children, getting married or divorced, or buying or selling assets such as property. Something that many people are surprised by is the fact that your will is revoked when you get married, unless you made your will in contemplation of that marriage. This means that any previous wills you made become invalid and you would need to create a new one to reflect your current wishes and circumstances. So that talks about marriage. On the other hand, if you get divorced, your will remains valid and only the parts in your will that favour your former spouse are automatically revoked. For example, any specific gifts made to them or their appointment as your executor. So they're 2 major life events that should prompt you to make a new will. If there's anything you'd like to discuss with us before making a booking, please do get in touch and one of our team members can have a chat with you about any questions you may have. In addition, if you're in a regional or remote part of Victoria, or if you have mobility issues, you may be eligible for a virtual appointment or a home visit from one of our representatives. Just keep in mind that additional fees may apply for off-site appointments.
Amazing. Thanks so much, Grace, for taking us through the will writing experience. Now we're going to be moving on to the second part of the webinar, which will be the Q&A session. So this will include answering any questions that you've popped into the chat and some common questions that we do often get. So while we are just gathering those questions in the back, I did just want to share with you that if you do book a will or power of attorney appointment this June, you will get 20% off if you attend by August the 15th. So it's a great opportunity to get everything in order at a discounted rate. Okay, I think we are ready to go. So Grace, first question, who can make a will?
Yeah, that's a great question. So anybody over the age of 18 years with testamentary capacity can make a will. So when we talk about testamentary capacity, we mean that the person making a will understands what a will is, understands the nature and extent of their estate, and the potential claims of those who might expect to benefit from their will. The will maker must also be able to make decisions about how to distribute their estate without being influenced by external pressures or any other issues which may affect their ability to think clearly about their will.
Great, thank you. And next up, what actually makes a will legally valid? Are there any specific things that we need to do?
Yeah, another great question, May, thank you. So the Wills Act states that a will must be a document in writing that is signed in the presence of two witnesses at the same place at the same time and be made with the intention of that document being a will.
Right. And what happens if someone passes away without a valid will? Is it really a big deal?
Yeah, I guess what happens if you don't pass away? If you pass away and you don't have a valid will, you won't have a say in how your estate is distributed. The question is, can you really live with that? The law determines who benefits from your estate when you pass away without a valid will. They also nominate who's responsible for managing the process and making financial decisions on your behalf. And that may not reflect your assumptions, expectations, or wishes of how your estate will be managed once you pass away. A few other points to note, your estate may take an extended period of time to finalise, for example, more than 12 months. The cost to settle your estate may be significantly more than if you'd written a will in the first instance, and ultimately that wears down the value of your estate. So in summary, every Australian really does need a will, even if you're single, even if you're without dependents, if you don't have many assets, or if you think your circumstances are straightforward. I like to think of making a will as an act of kindness to your loved ones, knowing that your affairs will be in order when you pass away.
Thanks, Grace. So it does sound like a pretty big deal to have one in place. So if I'm thinking about making a will, what are the key things that I should consider?
There's a few things that you should turn your mind to when you think about making a will. So firstly, who would you trust to be your executor? And not only who would you trust, but are they capable and are they willing to take on that responsibility, because it is a big one. You should also think about any specific gifts you'd like to leave and to whom. So I've mentioned a few times earlier, there might be a piece of jewellery that's special to you that you'd like to leave to a certain person, or there may be other sentimental objects that you'd like to leave to a specific person. You should also have a think about who you'd like to appoint as guardian to any minor children in your care. So again, children below the age of 18. And then finally, who is to receive the remainder of your estate after all of those specific gifts have been distributed?
Thanks, Grace. There's lots to consider there. And I think that when you mentioned the pre-appointment questionnaire earlier as well, so that would be really important to take on and put the plan to a page. Now, you did mention executor, and it's been mentioned quite a number of times. So what is an executor and why is it so important to nominate one in the will?
Yeah, so an executor is somebody who you choose to manage your estate and carry out the wishes in your will after you pass away. Your executor will ensure that your assets are distributed according to your will, handle any outstanding debts and taxes, and oversee the overall administration of your estate. They can also apply for your death certificate, apply for a grant of probate, handle debts and bills, as I mentioned, prepare tax returns which may be necessary, and resolve any estate disputes if they do pop up.
Okay, so why would I consider a professional executor like State Trustees?
So many Victorians, through my experience, many Victorians prefer not to burden their loved ones with the complicated financial and legal matters that an executor is responsible for. That's where a professional executor service like State Trustees can be a really great option. We also have an Executor Assist service to help support executors fulfil their obligations, and there's some more information about that service on our website for those who are interested.
Okay, great. So it sounds like the professional executor probably do a lot of the heavy lifting when it's a really emotional time for people as well. And you mentioned Executor Assist as well, which is really great service for anyone that is an executor and they get stuck. They can always contact State Trustees for any assistance there. And while you are writing a will, are there any traps that you should avoid?
Yeah, so there are a few traps that come to mind. So, of course, firstly, the big one is not getting the help of an expert to guide you through your options, appointing an executor who isn't willing or able to act, not including a clause about your residuary estate, not storing your will safely and securely, not dating your will or having it signed before two witnesses, not using the same pen to sign your will. And that does trip up a lot of people when witnessing their wills. It's not about just everybody using a blue pen, one's a gel pen, one's a biro. It's using the same physical pen. Not using a consistent signature across all of the pages in your will. And another big one that people often don't think about, and they think they're doing a good thing, is attaching documents to your will. You should never attach anything to your will. It should be a standalone document.
It's some really great tips there. Now, a question for couples. What happens if your partner passes away and you have a joint bank account?
Yeah, so joint assets such as bank accounts are subject to the rule of survivorship. So that means when one account holder dies, the surviving account holder automatically becomes the owner of that account and its funds. And that is the same with property held as joint tenants as well.
Amazing. And can I include superannuation in my will?
This is a question that comes up a lot from our clients. So super generally doesn't form part of your estate because it's held in a trust within your super fund. So that means that your super fund is the trustee and they're responsible for deciding who your super goes to through the rules of their fund. Alternatively, if you've prepared a binding death benefit nomination, that's how the super fund will decide how to distribute those monies. Ultimately, we can include a note in your will about how any proceeds from your super should be distributed if it is ultimately paid to your estate, but really it does need to be dealt with through the super fund directly.
Fantastic. And earlier on, you did mention that you can nominate charities within your will as well. So can you donate to more than one charity?
Yes, absolutely. Our team can help you with donating to charity and help you to decide what charity is appropriate based on the size of your gift, the cause that you'd like to support, and the impact you may wish to create. You can include one-off gifts in your will, or you can leave a legacy gift from your estate as well, which can be held in a charitable trust that provides ongoing financial support to your chosen charity or cause. This can be done through an already established trust, like the State Trustees Australia Foundation, or via a private charitable trust, which we can set up for you. For those interested, there is more information about charitable giving on our website, which may be helpful.
Brilliant. And another question for couples again, can you create a joint will with your husband or your wife?
Yeah, that is a very common question that we get. No, a will is an individual document. That being said, we do offer couples appointments, and generally spouses prepare wills that mirror each other. We call these mirror wills. So we can't do a joint document, but we can provide documents that mirror each other, which is what most couples do when they come in to see us.
Yeah, great. And can I include overseas assets in my will?
Yes, you can include a direction for your will to have effect worldwide. If you do hold assets overseas, though, you should check whether the other country in which you hold those assets require you to make a will locally as well, because we couldn't advise you on that. But we can certainly have a direction in your will to say that it has effect worldwide.
Fantastic. So once I've nominated an executor, how does the executor or any family members actually find the will?
Yep, another great question, because we need the original document to kick off the next steps, let's say. So the best way for your family members to know where your will is located is for you to tell them. So, I have my will at home in my filing cabinet in the bottom drawer. You can simply tell that to your executor. However, for peace of mind, State Trustees also has a registry service that registers the location of your document. It's free It's available for all Victorians. You simply fill in a form online and we'll keep a secure record of where you've kept your original will. And then once you pass away, your executor simply needs to prove to us that you've passed away and prove to us that they're the executor, and we'll tell them where you've told us that your will is located. You can also choose to deposit and store your original documents with us in our secure will bank. Alternatively, as I mentioned, you can definitely store it yourself. You can tell us where it's located and we'll make sure that that information flows through to your executor.
Fantastic. And so again, another executor question. So if someone does appoint state trustees as the executor, are there any costs involved?
No, there's no fee to appoint state trustees as your executor. However, similar to law firms, there are fees associated with state trustees administering your estate. This information is readily available on our website, and we may be able to provide a link to that to our audience, but it's all on our website. It's very transparent how our fees operate.
Great. And are there any ways to prevent my will from being challenged?
Yes, there are two things that come to mind. So having your will written by a professional will writer is the first step to prevent any challenges being successful, because we understand what to look out for and we can talk to you about the things that you might need to consider. So people often challenge a will if they feel that they've been unfairly excluded. If you exclude a potential beneficiary, you can write a letter to accompany your will, which explains your decisions as to not include them in your will. And that letter may actually help minimise the chances of that person successfully challenging your will. So these are definitely things that we'll talk to you about, if appropriate, during your appointment.
Yeah, that's great. And again, another executor question for you. Do you recommend having a substitute executor?
Absolutely. I would always strongly suggest nominating a substitute executor as a backup. So for many of our clients, they appoint state trustees in that role because they know that if their first, or let's say preferred, executor isn't available, isn't willing, if they pass away, whatever the situation may be, they can still trust state trustees to be available, to count on them to act when the time comes.
Fantastic. And when should I consider making a new will? What if the will's, over 40 years old?
Yeah, great question. So it's important to revisit your will when your circumstances change to make sure that it still reflects your wishes. So a will from 40 years ago may be very different to what you would want in your will today. As I mentioned earlier, life happens, people get married, people get divorced, and a lot can happen in a 40-year span. So having a look at your will every so often, every year, 5 years, to make sure that it's still relevant is really important.
Okay, and we mentioned, letting your executor know where the will is, but in terms of your beneficiaries, should you give them a copy as well?
That's ultimately up to you as the person, as the will maker. Whether you provide anyone with a copy of your will is entirely your choice. You're under no obligation to do that.
Okay, great. And if I have any foreign assets, can I include them as well?
You can, similar to what I mentioned earlier, we can make a note that your will is to apply worldwide. But again, I would strongly suggest making some local inquiries about how to deal with those foreign assets before you come in to see us, so that we know how best to deal with those overseas assets.
Fantastic. And when I make a appointment with a will writer at State Trustees, what will be the cost for the meeting?
Yeah, so a standard will costs $330, including GST, but discounts are available if you book as a couple, for example, if you're a concession card holder, or if you nominate state trustees as your executor or financial attorney.
Amazing. And so wills for people with religious beliefs, is there a way to accommodate for them and for the will to be tailored?
Yeah, absolutely. So we write wills for people of all different faith denominations. We can absolutely include some custom, for example, some custom funeral wishes or other wishes that you wish to come into play after you pass away. absolutely open to discussing that during your appointment.
Great. And with the executors and the beneficiaries, can they actually be one of my children or the same person?
Yes, it can. They can absolutely. We would talk to you during your appointment if there was any conflict of interest. After we've looked at your circumstances, if anything such as a conflict of interest does come to mind, we would talk to you about that during your appointment. But it is common for parents to have their children nominated as the executor.
Great, thank you. We'll just bring up some questions that are coming through to the chat, so please keep them coming. So Grace, you mentioned earlier that the will might need to be updated. So is it necessary to update the will when children get married or there's grandchildren or when you buy and sell properties?
Yep. So they're all major life events. You know, buying or selling property is a great prompt for you to update your will. For example, if you've left a gift of your, for example, an investment property to somebody, you then sell that investment property, well, that's a big change, and you'd want to update your will to reflect those circumstances. In terms of your children getting married, another big life event, definitely revisit your will to have a look that it still reflects your wishes. Grandchildren are another great example, you may wish to include them in your will, for example, leaving them a small cash gift or leaving them some other legacy from your estate. So all great examples that would prompt somebody to update their will.
Fantastic. So there's been another question that's come through about what happens if there's no will when the person passes or a valid will can't be found?
Yeah, so then ultimately it's the process of letters of administration. So we touched on that earlier. So ultimately how your estate is distributed is in accordance with the law, and that may not be in accordance with your wishes. So that is definitely the importance of having a will, and also the importance of storing your original will in a safe and secure space, such as the service that State Trustees provides to store your will.
Yeah, fantastic. And when someone's nominated as an executor, can we assist with administering their estate?
Yeah, so we talked about the Executor Assist service that we provide. So even if State Trustees aren't acting in their capacity as executor, we can definitely provide support to your nominated executor. And that may be guiding them through the process, having discussions around what to do next. There's different levels of service that we could provide to those people, absolutely.
Yeah, fantastic. Another question is, when you make a will in Australia, is this just valid for Australia or is it worldwide?
Yeah, great question. We can do it either way. Essentially, we can make a note that the will is only applicable in Australia. Alternatively, we can make a note to say that it's applicable worldwide. But as I mentioned earlier, we would suggest that you make inquiries locally if you have foreign assets to check whether you need to make a will there as well.
Yeah, fantastic. And how long is a will writing appointment with someone from your team?
Yep. So if it's a single person making one will, that's an hour appointment. If it's a couple, it's a 2-hour appointment.
Okay, amazing. And just a follow-on question from that though. So if someone does come to the appointment and they don't have all of the information readily available for you for that appointment, what generally happens?
Yeah, so we would encourage you to keep your appointment, encourage you to come in and have that meeting with the will writer. We can help you to fill in the gaps. So it's not imperative that we have every single piece of information, but we'd like you to have an idea of what your assets comprise of. Basically, we want to understand what your estate may look like. If there are gaps, if you're unable to provide all of the information in advance, we can definitely talk to that during our appointment.
Beautiful, thank you. Another question's come up is, are you able to appoint State Trustees as an executor even if the will was prepared by someone else?
Yes, absolutely. If you're having your will prepared, either if you're doing it yourself, if you're using our online will service, or if you're going down to the local law firm to have your will prepared, you can absolutely nominate State Trustees as your executor, definitely.
Yeah, fantastic. And just to add on top of that as well, even when you mentioned the will bank before as well, even if it's not written by state trustees, we can still store the will with us as well.
Definitely.
And is there any requirements for who can be a witness? Can it be family?
Yes, so I guess it could be family. There was a time when beneficiaries or anybody named in your will wasn't able to be a witness. Those rules have since changed. But all of our appointments are done in person. So we will provide you with some appropriate witnesses and we will make sure that it's signed in a legally valid way.
Beautiful. And having nominated the state trustees as one's executor, how does state trustees know that you've passed away?
Yeah, that's a great question. So generally, a family member would call us and have that unfortunate discussion that you've passed away, and that's how the process gets kicked off. The family would generally let us know.
Beautiful. And good question about where are you based to book an appointment? We live regionally.
So we have two offices with a will writing presence. One is in Footscray, right near the train station. The other is in Dandenong, again, a short walk from the train station, with ample parking surrounding those two offices. If you're unable to come in because you live regionally, or for example, if you have mobility issues or some other disability that prevents you from travelling into one of our offices, we can absolutely accommodate a video appointment. Or, as I mentioned again previously, a home visit if appropriate. Just keep in mind that additional costs may be applied if we come out to your home.
Beautiful. Next question is about, can state trustees advise on tax issues for your estate, such as unrealised capital losses associated with assets?
Yeah, that's a great question. So, in terms of the will making process, we don't provide financial advice. That is something that you should pursue through your accountant or financial planner, for example. But when it comes time to actually distributing your estate, dealing with your estate, we do have a tax division that would make sure that all of the relevant tax and financial legislation is complied with, whether it's to do with capital losses or other issues, that'll all be dealt with in a legally responsible way.
Yeah, beautiful. And can you leave all your assets to your grandchildren instead of your children?
Yeah, absolutely, you can. Um, that may be a situation where we have a discussion with you about making sure that your will isn't challenged after you pass away, because the usual course, let's say, would be for you to leave everything to your children and then to their children, your grandchildren. But that's not to say that you can't leave everything to your grandchildren. It's just a discussion. It just may prompt a discussion from us about maybe writing that letter to explain your wishes, just to prevent or safeguard your estate from being challenged down the line.
Yeah, great. And how much does the initial meeting cover? Can I prepare my power of attorney with you as well?
Yeah, absolutely. So our model is a one appointment model, and that's why there's such an importance placed on that pre-appointment questionnaire. We want to make sure that we've got everything available for us when it comes time to holding your appointment, so that we can draft your will while you're sitting in front of us, and you leave an hour or two later holding that valid will in your hand. So how much does the initial meeting cover? It covers a lot. It covers a lot, and we also cover a lot before your appointment. Given your interest in preparing a power of attorney, absolutely, time permitting, we would love to do that during that appointment. If time isn't permitting, we'll just make another appointment for you to come back in and we'll get those additional documents sorted for you shortly thereafter.
Yeah, beautiful. And also with anyone that does have any personal questions or needs some personal advice, it's a really good idea just to book in an appointment with one of our will writers as well, and they'll be able to give you a bit more tailored answers to your questions as well. Just check if there's been any other questions. And just a reminder as well, the webinar is recorded, so we will share the link as well so that you can have a watch back for any of the questions that you might need answers to as well. Okay. Just checking through. Okay, I think we've got time for one more question. So Grace, if this is your second marriage and you need extra clauses to protect property for children when spouses pass, is there an extra charge to write the clauses?
Yeah, so we prepare wills for people who have been married multiple times. That's nothing new to us. So we certainly know how to draft wills for those bespoke situations. So generally, we could absolutely deal with that in the 1 hour appointment. If your will requires some additional time drafting, there may be an additional cost associated with that, but that's something that your will writer will talk to you about during your appointment. We'd never charge you without having that discussion first and you being comfortable with it.
Yeah, beautiful. Thank you. And thanks, Grace. It was really incredibly informative. So we've covered a lot of ground today. So I'm just going to go over some key points that we've touched on. So firstly, Grace did start by explaining what a will is and why it's crucial to have one, no matter your age and assets. So your will outlines who gets your estate, so everything from your house to your beloved pets, and who will be responsible for carrying out your wishes. Then Grace went into unpacking the will writing process. So we begin with the pre-appointment questionnaire that will help the will writers get an understanding of your unique situation. And this way, when you come into your appointment, they can hit the ground running. So then during the appointment, they'll discuss everything from appointing an executor to specific gifts for your loved ones and even care for your pets and donations to charity. And then Grace and her team will ensure that every detail is covered so that you can leave with peace of mind knowing your affairs are in good order. Grace then highlighted the importance of considering an enduring power of attorney and a medical treatment decision maker at the same time as preparing your will. So these documents will ensure that someone you trust can make financial, legal, and medical decisions on your behalf if you're unable to, with the enduring power of attorney for financial, allowing you to also nominate an organisation like State Trustees as well. And then finally, Grace explained the finalisation process. So how we make sure everything's just right to get your will signed and witnessed and store it securely. So just remember that if you need to discuss anything further or make a booking, please don't hesitate to reach out. And if you're in a remote area or you can't make it to one of our offices for any reason at all, we can arrange home visits. There will just be some additional fees that will apply. We did also cover a range of common questions, so things like handling joint bank accounts and including superannuation in your will, to donating to charities and preventing challenges in your will. Now, we know that there were some questions that we couldn't get to today in the chat. So do keep an eye on your emails where we'll share the answers to all of those questions along with some helpful information as well. So where to from now? So to start your will writing journey, you can book an appointment with a will writer either in our Footscray office or our Dandenong office. So you'll also notice in the chat that we've included a link to our website booking page and our phone number as well. So you can use either of these to book in with us. And don't forget that if you're unable to make it to one of our offices, we can come out to you. If you are interested in this service, you'll just need to email us. And again, there'll just be some additional fees. And I wanted to remind you again that for any bookings that are made this June, you will receive a 20% off discount from your appointment, as long as the appointment is attended to by the 15th of August. Lastly, I do want to thank everyone again for joining us today and making this really important step towards ensuring that your financial and legal affairs are in good order. And we truly appreciate the level of engagement that we've received, especially the great conversations and chat questions that we've gotten. And your participation means a lot to us. And we're always here to support you. So please do give us a call to start your will writing journey. And just remember that, creating a will does give you peace of mind and security for the future, and it also gives peace of mind for your loved ones as well. So thank you again. Have a wonderful day, and we hope to see you soon.